Hi, Tony DeWitt here, Missouri Appellate attorney and a guy who tries to make the law make sense on YouTube. Today we're going to talk about a rather unique feature of the law called forum nonconvenience and how it was applied in one particular case. Stay tuned. Forum nonconvenience is designed to make it possible where even if jurisdiction and venue are proper in a particular court, the case can be dismissed if there is a more convenient forum somewhere else, and that forum is seriously inconvenient for the defendants. So how does this work? Well, let's take a look at a case called the Panama radiation case. In that case, there was a company in Canada that made a piece of radiotherapy equipment. Essentially, it was a linear accelerator, a nuclear medicine product that was designed to treat cancers. And they made this product, but they had to get the software from a company in St. Louis, Missouri. And after they put the software on, they sold it to a hospital down in Panama. After the sale, they didn't think too much about it, but as they went through using the equipment in Panama, they started to see a number of very severe radiation burns, and people died from radiation poisoning. And it very quickly became apparent that the software and the hardware were not working properly. And as a result, they quit using the equipment, and the people who had been injured retained lawyers in Panama, and those Panamanian lawyers retained lawyers in the United States. And then they basically came to St. Louis because that was where the place that had made the software was located. As a result, they sued in St. Louis Circuit Court. They also sued the company that was in Canada. And when they do that, they have to use something called the Hague Convention, which is a long and arduous process of getting pleadings and other sorts of things translated. And you wouldn't think you'd have to translate it for Canada, but because there is a large French-speaking population in Canada, the complaint had to be translated into French as well as English. And then it's served according to a series of diplomatic conventions. After it's served, the parties have an opportunity to come in and answer. And of course, one of the first things the Canadian corporation did was they claimed that this was a seriously inconvenient forum because, first of all, they were not from the United States. Second, the injuries didn't occur in the United States. And third, the place where all of the witnesses and all of the plaintiffs was down in Panama. Well, I was actually part of the briefing team on that case for the plaintiffs, and we tried very hard to keep St. Louis venue. Of course, in that process, we demonstrated that, Panama was not really a convenient forum because its judicial system was, shall we say, a bit of a banana republic judicial system, and it really didn't matter who had the best case. It often mattered down there who had the most money. But eventually, the Court of Appeals, the Eastern District, dismissed the case and sent it down to Panama. I believe it probably was possible for plaintiffs down there to get a fair trial. But obviously, the case had a lot less value in Panama than it did in the United States, particularly in St. Louis. So that was sort of my first introduction to briefing a case involving forum nonconvenience. But now what I want to do is I want to take you through a more recent case out of the Western District of the Court of Appeals in Missouri that deals with this issue.
The law in Kansas is generally bad for plaintiffs. It is one of the most conservative of jurisdictions when it comes to the issue of tort law. And for that reason, many times plaintiffs will go across the state line to sue in Missouri because Missouri has better law on almost all subjects as it relates to torts. So this is a case involving Mary and Jason Crawford and a company called Family Tree Incorporated. What happened here is Mary Crawford went to Family Tree's Garden Center in Shawnee, Kansas, and while walking to the entrance, she fell and was injured. In early June of 2022, Mary Crawford and her husband Jason, the Crawfords, filed a petition for damages against Family Tree in Jackson County, Missouri. They alleged negligence, premises liability, and loss of consortium. Family Tree filed an answer and on the same day also filed a motion to dismiss on the basis of forum nonconvenience. As you know, I've talked about forum nonconvenience before, and the issue in forum nonconvenience is whether the forum is substantially unfair and substantially inconvenient to the defendant. The motion was 2 sentences, which read in its entirety, Defendant Family Tree moves the court to dismiss this action under the doctrine of forum nonconvenience. Defendant incorporates its suggestions in support of defendant's motion to dismiss. It then filed accompanying suggestions in support with one attached exhibit, an internet printout for Family Tree's Garden Center location in Liberty, Missouri. The Crawfords filed suggestions in opposition to the motion with one attached exhibit, which was Family Tree's application for a certificate of authority filed with the Missouri Secretary of State's office in 2021. The Crawfords opposed the motion to dismiss, contending that Family Tree failed to provide that the factors in the Reederer case, is what we'll call that, weighed heavily in favor of Family Tree and failed to demonstrate that permitting the case to be tried in Jackson County would be oppressive, prejudicial, and manifestly unjust. And those are the case law standards. Discovery was not conducted before the motion was filed, and it does not appear that any occurred after. The trial court did not hold a hearing on Family Tree's motion, but notified the parties that it intended to grant the motion to dismiss and requested that Family Tree submit a proposed judgment. Family Tree submitted a proposed judgment to the court, and the Crawfords filed an objection on the basis that it contained facts not introduced into evidence and misstatements of law. On August 10th, the court entered its judgment, granting the motion to dismiss on the basis of forum nonconvenience. The trial court considered the Reederer factors and found that all but one, the location of the witnesses, weighed in favor of dismissal. The Crawfords appeal. So the court goes through the standard, and the standard for forum nonconvenience is abuse of discretion. And it says an abuse of discretion occurs when the trial court's ruling is clearly against the logic of the circumstances and is so arbitrary and unreasonable as to indicate a lack of careful consideration. The trial court has broad discretion, but it is not unlimited, and it must be applied with control. If reasonable persons may differ as to the propriety of the action taken by the trial court, then it cannot be held that the trial court abused its discretion. We consider only those facts that were before the trial court when it ruled on the motion to dismiss, and the evidence will be viewed in the light favorable to the result of the trial court. In their first point on appeal, the Crawfords contend the trial court erred in entering a dismissal based on forum nonconvenience because Family Tree did not establish and support with evidence that Crawford's forum choice was manifestly inconvenient. And this is something that usually new lawyers do. They will file a motion and rest on the motion. But courts routinely tell folks that a motion is not self-proving. In other words, just because you file a motion does not entitle you to relief. You have to bring the court the facts necessary to decide the motion. So let me show you what we're talking about here. Location down here at this end of the picture, right here, is actually the courthouse in Johnson County, Kansas, which is where the case would be tried if it was tried in Kansas. And this is where the Independence Courthouse is located, where the case was venued in Missouri. As you can see, it's 26 miles. 26 miles right here. That is a very short distance in terms of travel. In fact, there are numerous locations in Kansas and even in Johnson County where it is further to the courthouse than 26 miles. This image shows on the bottom left near the word Shawnee, the location of their Shawnee store where the accident occurred, and then the location of their property up in Liberty, Missouri in Clay County, where they own a garden center up there. It's about 20 miles. So the distance between the two courthouses was only 26 miles, and the distance between the two business operations of the same company was only 20 miles.
Well, as you can see, there's not very much of a difference between a 20-mile distance and a 26-mile distance, and it's really hard to complain that something is seriously inconvenient if you go to a further distance every day or at least every week to do business in your Missouri store, even though you're a Kansas corporation.
In their second point on appeal, the Crawfords contend the trial court erred in dismissing their claims because the Reader factors don't support a finding of inconvenience. Family Tree argues that under the forum nonconvenience was appropriately based on the uncontroverted allegations in Crawford's petition, and that Family Tree did not need to present additional evidence. We'll discuss the Crawford's points on appeal together. The doctrine of forum nonconvenience permits a court to dismiss an action if the forum is seriously inconvenient and there's a more appropriate forum available to the plaintiff, even if the venue and jurisdiction are proper. And in this case, the venue and jurisdiction were both proper before the trial court. The doctrine is to be applied with caution and only upon a clear showing of inconvenience and when the ends of justice require it. A plaintiff's choice of forum is not to be disturbed except for weighty reasons, and the case should not be dismissed, or a case should be dismissed only if the balance is strongly in favor of the defendant. So the court then goes through all these factors, which we don't need to get into, but applying the first factor, which is the cause of action did not accrue in Missouri, well, that definitely works against the plaintiffs here. Crawford visited the Family Tree Garden Center in Shawnee, Kansas, where she was allegedly injured. That factor weighs in favor of dismissal. The second factor is location of the witnesses. And Family Tree indicated the witnesses that would testify to the elements necessary to establish plaintiff's claims are located in Kansas. At this early point in litigation, there are no known witnesses in Missouri. The trial court found it's unclear at this early point in the litigation if there are any witnesses located in Missouri. The location of the witnesses does not weigh in favor of dismissal because, as the Crawfords point out, the names of witnesses have not been disclosed and the names were not contained in their petition. Therefore, it follows that Family Tree cannot establish that any witnesses would be inconvenienced by appearing in Jackson County. The third factor is the residence of the parties, and here the court even went further than the plaintiffs in their suggestions in opposition. Family Tree claimed that although it had a Missouri presence, it was only a resident for venue and jurisdiction purposes, but not for forum nonconvenience purposes. The trial court acknowledged the following. While Family Tree may be a Missouri resident for purposes of venue and jurisdiction, it's not a Missouri resident for purposes of forum nonconvenience. The trial court summarily found that all the parties were Kansas residents and this weighed in favor of dismissal. While Family Tree is a Kansas corporation, it fails to acknowledge that by availing itself of the ability to do business in Missouri, it also becomes a Missouri resident for purposes of the venue statute. A foreign corporation authorized to transact business in the state is required to continuously maintain a registered office in the same state and a registered agent who may accept service or process. There is no support for the trial court's distinction that while Family Tree is a Missouri resident for venue and jurisdiction purposes, it is not for forum nonconvenience analysis. Here, the trial court discounted both that Family Tree operates a garden center in Clay County and that it had registered agents in Jackson County. There's no evidence that Family Tree has so significantly limited its Missouri operations that it may not be considered a Missouri resident. This factor does not weigh in favor of Family Tree. The fourth factor is whether there is any nexus with the place of the suit. The trial court found there was no substantial nexus, but whether there is a substantial nexus is not the applicable test. All that is required is a showing of any nexus or some nexus or a nexus of community integration with the place of the lawsuit. Here there is a sufficient nexus to deny dismissal because the suit was brought in a forum in close proximity to where the events allegedly occurred, and Family Tree operates a business with multiple locations across the metro area, one of which is in Missouri and two of which are in Kansas. So basically what the defendant was arguing here was that it is manifestly inconvenient, just oppressive, to have to come into Jackson County and litigate this case, but it's not oppressive to drive a few extra miles into Clay County and operate its business in Missouri. So I think that argument fell fairly flat with the court. And then it discusses a couple of cases, and it is reasonable for Family Tree to expect to be sued in the county where its registered agent is located. A sufficient nexus exists with the place of the suit, and this factor does not weigh in favor of dismissal. The fifth reader factor is a public factor of convenience to and burden on the court. The trial court concluded the case should be decided by Kansas jurors and paid for by Kansas taxpayers, and that to litigate in Missouri would heavily inconvenience the court and Missouri residents. The court then says statistical data may be submitted to support a claim that the caseload of the trial court is so overwhelming that the case cannot be expeditiously litigated in the jurisdiction where it's filed. Such matters as taxpayer cost, jury time, and the necessity to interpret and apply the law of the foreign jurisdiction, and similar facts may be offered and weighed by the trial court. In addition, the trial court may take notice of the congestion of its own docket. Here, the Family Tree offered no statistical data. That's because it submitted absolutely no evidence in support of its motion. And the trial court's reference to applying Kansas law and the inconvenience it would cause a Missouri jury does not alone justify dismissing Crawford's case. Missouri courts are capable of applying the laws of other states without creating an undue burden on the court system. And that's from a case called Taylor. The mere fact that the trial court must apply a foreign jurisdiction's law to an action does not burden the court enough to support a dismissal. Finally, the sixth factor, the availability of another court with jurisdiction. In their brief to this court, the Crawfords admit they could have filed their claims in Kansas. In its judgment, the trial court summarily concluded that Kansas provides an available forum, and it's the most convenient forum for the Crawfords. The Crawfords having the ability to bring a suit in Kansas where the witnesses and evidence are more readily accessible. The trial court made these conclusions without any evidence in support. No discovery had been conducted to identify the witnesses and evidence, so it would be impossible for the trial court to predict which location would be more accessible or convenient. Therefore, this factor does not weigh. In this case, it appears the trial court's conclusions on the factors were framed by Family Tree's assertion that were not supported by evidence. Family Tree contends Crawford's petition contained ample facts to support dismissal for forum nonconvenience, and the trial court was permitted to rely on those uncontroverted allegations in the petition, and that the petition itself provided the necessary facts to make the evaluation. This, however, ignores the fact that the allegations in the petition were not uncontroverted. Family Tree filed an answer and specifically denied many of the allegations in the petition. The Crawford's residence was only one of the reader factors that weighed in favor of dismissal, but even this was an allegation in the petition that Family Tree denied in its answer. So the court wound up saying that none of the reader factors applied, and Family Tree failed to establish that the reader factors weighed heavily in favor of dismissal. Then it decided the issue of oppression to Family Tree or undue burden on the Missouri courts, and it reached pretty much the same conclusion there. Family Tree failed to demonstrate that permitting this case to be tried in Jackson County would be oppressive or an undue burden on the courts. And so, as a result, it determined that the case should be reversed and remanded to the trial court for further proceedings.
I think the Court of Appeals got it exactly right here. But again, this gives me an opportunity to underscore an important fact with respect to motion practice in any court. And that is that motions are not self-proving. You have to introduce evidence and prove that you're entitled to the relief that you seek by a motion. And if you don't do that, in most cases, you will lose. The court will either, say, I'm denying the motion with leave for you to refile it with more evidence, or it will simply say, I deny the motion, in which case you have to ask for leave to refile the motion. So the better practice is always to support any kind of motion that you make, whether it's a motion to dismiss or a motion to compel production of documents, any of those sorts of things. Always better to support those with some evidence that supports what the relief that you want to have. Well, that's what I have for you today. I hope that it was interesting and useful and informative. If you have the opportunity today, go out of your way and do something nice for someone. Maybe buy your wife some flowers, or maybe buy your husband something that he wants. Just do something that makes somebody else feel good, because you can't do that without making yourself feel good. Trust me, I know. If you have an opportunity and you've enjoyed the content here and you haven't subscribed yet, I'd love to have you as a subscriber. And for all of those who have subscribed, thank you very much. Have a wonderful day, and I will catch you down here at the beach next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.